Swayam Prabha. Digital India. Educated India.
Greetings to all the learners. Now, we have studied about the liberalization of the power market. We have also taken a kind of overview that how power market works through the power exchanges. Now, in today's session, let us try to understand that what are the main provisions of the welfare of consumer under the Electricity Act, because if you look at the scheme of the law suggests that apart from making the sector competitive, there is very prominent stress on serving the interest of the consumer also. So, in this session we will be talking about how consumer is featuring under the Electricity Act 2003. We will look into the provisions which cater the interest of consumers, and then we will also try to identify that what are the institutions which are provided under the Act to protect the interest of the consumers. Now, when you look at the participation of consumer in the power market, it has its lineage prior to 2003 Act. In 1998 Act, which brought in Regulatory Commission into existence, it was stipulated there that the Regulatory Commission should consult public and there shall be public hearings before deciding on the regulations. Now, when you look at these kind of provisions in the law, what purpose it serves? One has to understand that when public service transfers from state to market, then there is a task to involve the consumer, involve the public before deciding on the necessary mechanisms to operate the market. Now, electricity is certainly an important public service. The delivery of the service was earlier in the hand of the states under 1948 Act, as we have discussed. Gradually, because of the poor financial health, because of the mismanagement, it was decided that electricity boards are to be unbundled and efficiency of this sector would be possible only when we liberalize the market. So, obviously, there has been a shift in a sense that what was earlier entrusted to the state, now it has been provided to the market players. But then we know very well that market has its own way of dealing with the things, because basically it survives on profitability, and in order to regulate that, in order to ensure that the players in the market should not only look at profiteering, but also look at the larger social cause of ensuring the availability of public service to all, rightfully it has been decided to incorporate the provisions under the law itself, so that it is the law which shall govern the players of the market. It is the law which shall determine that whether the necessary steps are being taken in the direction to fulfill the objectives of the law or not. So, 1998 Act provided for public participation, provided for public consultation and hearings in decision making process. One may look at this from the perspective of either a democratic approach, where the affected are to be consulted, are to be taken on board, or it has to be also seen from the consumerist approach, where external factors are to be taken into account before channelizing, before deciding, before providing any guidelines. Carrying on from that legacy, 2003 Act highlighted the significance of addressing the interest of the consumer at the preamble itself. If you look at the language of preamble, it serves to understand the mind of the lawmaker. And what the language indicates? It says that on the one hand, there is a responsibility to promote the competition. On the other hand, it also suggests that the interest of consumer shall be protected. That is what the language of the structuring of preamble suggests. And we know very well that the rationale of including preamble in the statutory scheme is to understand the mind of the lawmakers. It is the preamble which facilitates the interpretation of the individual provisions. It is the preamble which helps in clearing the ambiguity which is there in the law. It is the preamble which helps in giving a direction and direction to all the stakeholders. Now, the term consumer is defined under the Act. Section 2 subsection 15 defines consumer. It says any person who is supplied with electricity for his own use, and includes any person whose premises are for the time being connected for the purpose of receiving electricity. So, what is important to note here, that the consumer is one who is getting the electricity for one's own use, not for further resale. If the electricity is being received, if the electricity is being supplied for further resale, then the definition will not get attracted. And also this definition covers a situation where there may not be any consumption of electricity taking place in a particular premise, but then if the premise is connected for the purpose of receiving electricity, then the owner of the premise, the occupant of the premise will certainly be called as consumer. So, consumer here has to be understood in terms of the one who is ultimately the beneficiary of this industry, the one who is deciding the consumption pattern And in the rules of 2020, there has been an addition done, or the clarification has been made, I would say, where occupier has been defined as the owner or the tenant or any person who is in the occupation of the premises. Now, what change this clarification has brought? Because many a times it so happen that the electricity connection has been taken in the name of the owner, and if the owner gives the premise on rent, then the billing and everything is done in the name of the owner only and not in the name of the tenant. Now, there may be a situation where the owner may have a different load, wherein the tenant may not have that kind of load, and thus the fixed charges which are to be paid may vary. Now, this definition will certainly address this issue and ensure the optimal use of electricity at the end of consumers. Now, when you look at the provisions with regard to the interest of consumers under the law, you would find that there are several provisions which talk about that. The most prominent one to my mind is universal service obligation, which we have discussed in detail while discussing on duties of distribution licensing. Universal service obligation, why it is the most prominent one to me? Because it is in a way confers a statutory right in favor of the consumer to get quality and reliable supply. It ensures that the distribution licensee shall be bound by the terms and conditions, and not very difficult to visualize that the terms and conditions are ultimately being prepared to advance the interest of consumer. So, universal service obligation is the most prominent provision, I would say, to address the interest of consumers. Open access, we have again talked in detail about this. This is also to be linked with the interest of consumer. Why? Because open access now gives the choice to the consumer. Choice to the consumer from whom to buy electricity. And in this process, as we have discussed, will create an ecosystem where the consumer will get electricity on affordable price. That is what open access promises to consumer. You have a provision where it says that if the distribution licensee fails to maintain uninterrupted supply of electricity as per the standards specified, then that should be a reason, that should be a factor to suspend the distribution license. Now, look at the way the law has given importance to the satisfactory service to be extended to the consumer. It says that if it is not been done, that is good enough a reason for suspending the license. As a law student, we need to understand the significance of the word persistent, which certainly would mean that if it is one-off instance of uninterrupted supply, it would not be a valid reason to suspend the license. There has to be a regular interruption, a sort of continuous interruption. So, the lawmakers have certainly considered consumer at the focal, at the core of the growth of the power sector. Section 57 talks about standard of performance which is to be followed by the licensee. What shall be the standards? Section says it is to be laid down by the commission, and the commission shall consult the licensee as well as the person likely to be affected. So, look at the way the law integrates consultative process in decision making aspect. It is not about thrusting upon, it is not about imposition, it is more about hand holding, it is more about understanding the concern of all and accordingly frame the regulation which creates a win-win situation for everyone. So, standard of performance to be laid down, but if the standard is not being followed by the licensee, section 57 says there shall be a penalty. So, penalty has been laid down there. So, consumer can very well approach the commission, consumer can very well indicate that, see, what you have agreed to, you are not conforming with the same, and therefore, you should be made liable. Now, even when you look at the issue of tariff determination, which is the responsibility given to the appropriate commission. Now, in that you would find that one of the considerations to be kept in mind by the commission is safeguarding the interest of consumers. But then safeguarding the interest of the consumer must not be at the cost of distorting the market, and that is why it says safeguarding of consumers' interest and at the same time recovery of cost of electricity in a reasonable manner. So, when consumers' interest has been taken into account, at the same time it is also to be factored in that whether the recovery is lesser than what is the cost of production. Otherwise, market cannot sustain, otherwise industry cannot grow. But at the same time, it is also important to take note of what section 62 subsection 3 says, that while deciding on the tariff, undue preference is not to be given for any set of consumer. One should not be preferred over another, but then certain factors are to be considered for determining the tariff. Load factor, power factor, voltage, total consumption of electricity during any specified period, or the time at which supply is required, or the geographical position of any area. Now, when you look at these categories, you can very well make out, you can very well understand that these provisions give a realistic touch to the power which is entrusted to the commission with regard to tariff determination. Why? What is realistic about it? That India being a country run on agrarian economy, you have to take note of the farming season, because supply of electricity during farming season should be better, should be more reliable. It has to be also considered that minimal quantity and quality should be ensured to every individual who is approaching the licensee for getting the electricity. That is what is the mandate of section 62 subsection 3. So, look at section 61 and 62 here together, you would find that appropriate commission has been entrusted with the responsibility, but then responsibility also says that yes, you consider recovery of actual cost, but do not completely overlook the interest of consumer. and then while working on the interest of consumer, you can very well come out with the factors of categorization based on consumption, based on load factor, based on need of electricity during a particular period of time, geographical location and all. So, very, very significant provision. Now, 65, which also we have discussed in detail, I am just connecting it with addressing with the, I am just connecting it with consumers' interest on this very count, that at the end of the day, if the necessary leeway is not extended from the players of the market, if it is necessary, cushioning is not been extended by the distribution licensee or by the appropriate commission. If such situation arises, or there are certain constraint in which necessary facility cannot be extended, then appropriate government can very well take note of it. Section 65 just certainly allows government to come up with the plan of subsidy. Now, look at the way section 64 and section 15(2) is been drafted. It says that regulatory commissions are required to consider all the suggestions and objections received from public before tariff and licensing issues. So, tariff, what 61 says, do the consultation, consider the suggestions which have come to you, and while granting the license under section 15 to distribution licensee, to transmission licensee or to the trading licensee, you must look at what opinion has been advanced by public at large. And then you would find that it says that if there is a default on the part of the consumer, default in paying the bill, then licensee can disconnect the supply of electricity. But then here what is to be taken note of is the expression any person neglects. There has to be an element of negligence here. It must be established that it is being done knowingly. If something happens unknowingly by accident, perhaps 56 may not be attracted. And it further says that let the licensee be bound to give clear 15 days notice to the consumer. And if consumer agrees to pay the amount under protest in a way that consumer is disputing what licensee is claiming, then there shall not be any disconnection. So, look at it the way the law has presented an opportunity to the consumer that if you are willing to pay even with protest, disconnection shall not be there. So, in all possibility, the connection must be maintained, connection must be ensured. And that is what also further says section 56 subsection 2. What it says that if the amount when it is first due is not been recovered within first 2 years, then it cannot be recovered later on. Very important provision. And why important provision? When this discussion was going on, the Parliamentary Standing Committee has suggested this, that if you do not have this provision, then perhaps the consumer will get harassed from the licensee. Then they will keep on revising the bill and they will keep on claiming the bill. And that is why it says that if it is not been recovered after the period of 2 years from when the amount is first due, certainly there cannot be any disconnection, there cannot be any cut off of the supply of electricity, a very important provision in the interest of consumer, that even if the amount is due, disconnection shall not happen. Now, look at the institutions which protect the interest of consumer. Section 42, which talks about the duties of distribution licensee, under subsection 5 entrust the obligation on the distribution licensee to establish consumer grievance redressal forum. This is the responsibility of the distribution licensee to establish as per the guidelines issued by the State Electricity Regulatory Commission. Now, this grievance redressal forum could be at different level, could be at the subdivision level, could be at the circle, zone, company level. It says that the forum is to be headed by an officer of the licensee. It says that the forum shall consist of officers of the licensee and having not more than 4 members, and then there has to be consumer also there and prosumer also there. So, 4 of them should be from consumer and prosumer, and then appropriate commission shall also nominate one person who shall be an independent one and the one who is familiar with consumer affair. There is a question here that how do you see the officer of the licensee chairing the redressal forum? There is a highly likely that the officer may have soft approach towards the licensee and may try to engage into a kind of cover up. Maybe, I mean, it cannot be said with certainty, but then some of the studies suggest that if you have a retired employee of the licensee as the chairman of the forum, perhaps it would serve the purpose better. But then again, this is all about the probity and integrity of the institution. The nature of proceeding before the forum is about self-correcting mechanism, and therefore, it is very informal. It is all about settling the dispute in a very amicable way, probably through a conciliation proceeding where grievances are being raised. It is to be heard that who is at the fault, and then try to look for a situation, try to look for a solution which will bring win-win situation for both the parties. So, it is a sort of in-house mechanism, and that is how we need to understand that what shall be the nature of proceeding legally speaking. Why I am highlighting on this? Because if there is a question of if there is a question that whether lawyer should be allowed to be represented the client to represent the consumer at the forum or not, the answer should be no. But then the question comes if the licensee is being represented through a lawyer, then what shall happen? Then consumer should be allowed for maintaining the parity. So, ideally neither licensee nor consumer should be allowed to be represented through a lawyer. Now, if someone is agreed by the decision of the forum, it can make representation before the ombudsman to be appointed by the regulatory commission. So, consumer redressal forum is appointed by distribution licensee, ombudsman is appointed by the state commission under section 42 subsection 6. Now, if you look at the language which helps you in understanding the role and responsibility of ombudsman, it says shall settle the grievance of the consumer. Settle word here indicates that there is a responsibility entrusted on the ombudsman to adjudicate the dispute and to give a final verdict, unlike what you find in forum where conciliation has to be there. So, adjudication is something where it seems is the kind of function which is entrusted on the ombudsman, and as per the language it is only the licensee who shall be at the receiving end, who shall not be allowed to approach, because there is a possible, there is always a possibility that if forum decides in favor of licensee, or if the forum decides against the consumer, licensee would not prefer to appeal against that decision. So, only when the decision is against the consumer, consumer would come before the ombudsman. So, licensee generally is not to be allowed, because there is no grievance, there is no cause of action for licensee to raise. Ombudsman is also been asked to prepare a report that what kind of grievances have come before the institution, the ombudsman, what are the responses of the licensees, what is the opinion of ombudsman, and it is to be submitted to the commission and to the government within 45 days. It will certainly, why this very process, you can very well make out, this process is more about engaging with the consumer, that this report will serve the purpose of revealing the grievances which the consumer is presenting before the distribution licensee, and on that commission perhaps can take lessons, can learn lessons, and then revisit the regulation. And same with the government, government can very well give the necessary advice to the appropriate commission as and when situation is needed. You have rights of consumer under the other provisions intact. Section 42, it says that if consumer has a right under different laws, let us say for example, under Railways Act, under Consumer Protection Act, that remains intact. Electricity Act does not adversely affect the same. Then if, as I said, standard of performance is not been met, penalty can be imposed. If universal service obligation is not been met, penalty can be imposed. So, that is what is the power there with a CRC. And then point is that can grievance redressal forum and ombudsman, can they also impose penalty or compensation? The understanding is that their role is only to settle the grievances, and therefore, whatever they order they issue, it should be seen to be an order similar to the regulation passed by the Regulatory Commission under section 142 of the Act. So, any issue of penalty or compensation, it is for the appropriate commission to deal with, not for the grievance redressal forum or for the ombudsman. Now, further provision, when you look at it, you find that Central Electricity Authority, which is an advisory body, while considering the matters, it has to keep in mind reliable and affordable electricity for all consumers. So, that is one of the functions which has been entrusted under section 73A. Also with Central Advisory Committee, which is to be established by Central Electricity Regulatory Commission, there again amongst the who shall be the members, it is suggested that one set should always be the one which is representing the consumer, which represent the interest of the consumer, that is what it says. And State Advisory Committee provision is also there under section 87. There again states that member must be drawn from the consumer's representative. Then same, when you look at what is the responsibility of the committee, it says that the committee shall advise the commission to protect consumers' interest. So, you look at the way the institutions are being provided, not only the one which has a responsibility to directly deal with the consumer or the grievances of the consumer, but also at the policy making level, the consumer's viewpoint is to be looked at. And then appropriate commission has been given the necessary authority that if some issue comes up on adjudicatory side, then it can authorize any person to represent the interest of the consumer. So, that consumer's perspective should also be considered before taking a final call. In addition to that, when you look at the Central Advisory Committee, State Advisory Committee, you also have a district committee under section 166, when it says that appropriate government can very well establish district committee, and that is one of the objectives is to review the quality of power supply and consumer satisfaction. So, that is what it sees. And then when you look at how broader is the definition, a person who has supplied for a new connection, he is not already a consumer, he has applied for a new connection, that person can also be called as consumer, and that person, if he is not satisfied, if his application is not been considered within a stipulated time, he can very well also approach the forum and then ombudsman. Now, this is an important judgment where you find that what has been suggested about the role of ombudsman. Superintending Engineer, Dharmpuri Electricity Distribution Circle versus Meenakshi Udyog India Limited, where you find that Madras High Court clarifies that ombudsman is not a mediator alone, he is also an adjudicator. So, the electricity ombudsman is an appellate authority under the regulation, and therefore, it has all the power which it can exercise while looking into the appeal made by aggrieved party against the decision of the forum. Then you have this case where the court has explained, the Supreme Court has explained that how do you understand the meaning of first due. It says assistant engineer, Ajmer Vidyut Vitran Nigam Limited versus Rahmatullah Khan, where the court clarifies what do you mean by first due. It says that as per the scheme of the law, section 56(1) confers a right in favor of licensee company that if payment is not been made on time, if it is not made during that stipulated time, licensee has a right to disconnect, but then that is subject to that 2 years timeline which has been given under section 56(2). But then can distribution licensee raise a supplement demand after 2 years? The Supreme Court in this Ajmer Vidyut Vitran Nigam Limited said yes, licensee can always raise a supplementary demand, but what licensee is refrained from doing under the law is licensee cannot disconnect the connection. Can always raise the demand, but disconnection is not allowed. Why? Because there is a statutory timeline given that the disconnection shall be allowed only within 2 years from the date when the demand is being made. So, for disconnection it is important that demand is being made by the licensee, and that is what is being not honored by the consumer. So, when you look at it, this is how the consumer interest is being addressed under the Electricity Act. Thank you.